Well, hello everyone and welcome. Welcome to this employment law session, to your employment law session. I'm Lior Samfiru, the employment lawyer. Yes, I'm one of the founding partners of Samfiru to Market LLP. We're the largest employment law firm in the country. You can find us in Ontario, in BC, and in Alberta. And once a week on Wednesday at this time, I like to come here, join you, and take your questions live. So again, I'm Lior Samfiru, the employment lawyer with Samfiru to Market LLP, and I'm here live with you for you to answer questions, to help solve workplace issues, to make sure you understand what the law says, what the law can do for you, what your rights are. It's unrealistic to think that things are always going to be fantastic at work. Sometimes there's going to be issues or questions, or maybe you're not sure if what your employer is doing is allowed, if it's legal. Ask the question. I'll tell you. You're not sure what to do, maybe if you're facing a workplace problem, your job is being changed, your hours are being cut, maybe your location, you're being told to come back to the office when you've been working remotely. I think you get the idea. Maybe you lost your job. So many people have recently. You need to understand what you're owed, probably a lot more than what you've been offered. So many things you can ask about. I'm here live to answer those questions, to provide you with that information. A lot of misconceptions out there when it comes to employment law. It's a dangerous place, Google can be, when it comes to trying to find out your rights. Don't make that mistake. Right now, you can ask the question, get the real answer specific to you, not hypothetical, not answers about someone else. You can get an answer about your situation. So ask the question. Again, I'm Lior Samfiru, the employment lawyer with Samfiru to Market. Before I start answering questions, I want to give you some other contact information. Excuse me, if you want to connect with me and my team at any time, so we can have a discussion beyond this live stream, easy to do. All you have to do is go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that address on the screen right now. And when you go there, you can find out lots more about employment law. You can find out lots more about workplace rights. And of course, you can connect with me and my team. You can ask a question. You can get the email address, the phone number. It's all there at employmentlawyer.ca. So you can do that at any time. But right now, I'm live with you. I want to have questions answered. Last week, we had a bunch of questions coming in. I want as many, if not much more, today. Don't be bashful. No bad questions. I promise you. I'm never going to say to you it's a bad question. I've never been asked a bad question in 22 years of doing this. So you have a chance to get answers. Let's get those started right now. I'm going to start answering questions. If you've just joined me, I'm Lior Samfiru, the employment lawyer with Samfiru to Market LLP. And I'm going to start answering questions, but I want your question as well. All right, let's see. Our first question today, and thank you, comes from Facebook from Echo. I've been working full-time as a full-time permanent employee for over a year. A few days ago, my employer sent me a renewal contract and asked me to sign it. It states that I'll be on a contract renewed annually. I'm hesitant to sign this. Is this legal? So it's not even a question of whether it's legal. It's a question of what happens if you don't. So if you don't sign this, your employer may let you go. Remember, your employer can let you go pretty much for any reason. But of course, your employer is going to have to pay you severance. And I know you've been there for a year. I don't know your job or how old you are, but you could easily be owed anywhere from 2 to 6 months of severance, maybe even more. So if your employer wants to let you go because you don't sign this new agreement, they can. I don't know why they would want to, but they can, as long as they pay proper severance. Now, if you sign the agreement, you have to assume you're going to be bound by the terms of that agreement. I don't want you to sign anything before I see it. Do not sign that employment agreement until I see it, because there could be other problematic things there that could cost you money. For example, there could be a term there that limits your severance. So I just told you you could be owed as much as 6 months severance. It's possible that once you sign the agreement, if they let you go a week later, you could be owed a week or 2 week severance only, because you could have limited yourself in that employment agreement. So word of advice for all folks watching right now. If you're already working, you have a job, you've been working, and your employer comes to you and wants you to sign a new employment agreement, be very concerned. It's not a minor thing. It's a big deal. Let me see it before you sign it. But certainly you're okay to say, I'm not signing that. You can't be punished for that. It's not something you should take lightly. Usually, if your employer wants you to sign a new employment agreement, there's a reason, and it's not a good reason for you, the employee. It's a reason that protects the employer. Okay, so hopefully that makes sense. Hopefully you understand what all that means. Thank you for that question. You see how easy it is, by the way, guys. Echo had a question, asked it, I answered it. Now that information is there. You can do the same thing. I want you to do the same thing. Ask your question right now of me, Lior Samfiru, the employment lawyer, and I'll answer it. So if you're watching, fantastic. The best thing you can actually do is ask a question. All right, let's see our next question. This one comes from YouTube from David. I'm 54. I've been with the same company for 3 years. My title was mechanical estimator. I did not sign any document to get my severance package. They let me go because I made a mistake in my estimate. Half my fault, half my supervisor. But I was a scapegoat. What can I do here? So the only time your employer can take away your severance or deprive you of severance is if you've done something awful. You've done something so bad that it's just not possible employing you. And making a mistake or screwing up, pardon my language, that in and of itself is not enough to let you go for cause. It's not enough to deprive you of severance. Now, if you've done this a bunch of times and they've warned you and you keep doing it again, well, yeah, at some point, of course, they're going to be able to let you go for cause and not have to pay you severance. But if this is an isolated incident, when you made a mistake, where you've kind of screwed up, that doesn't mean they can let you go for cause. Even if you made a mistake, even if you've done something wrong, in most cases, you are still owed your full severance if your employer lets you go. So in your situation, you made a mistake. Assuming this is an isolated incident, you're owed severance. You say you've been there for 3 years and you're 54 as an estimator, you could be owed 4 to 6 months of severance, okay? Probably closer to 6 months. That's what you're owed. So yes, you've been wrongfully dismissed if you have not received that severance. Call me, okay? I want you to connect with me off air. To do that, very easy to do, employmentlawyer.ca. That's it. That's all you need to remember, employmentlawyer.ca. You can get the phone number there, email address there. You can fill out a form if you prefer. It's all there for you. So David, yes, you've been wrongfully dismissed. You're owed as much as 6 months pay. That's a lot, right? So you have to connect with me as soon as possible. Again, employmentlawyer.ca. All right, that was our second question. This one from David. Thank you for that. Guys, hopefully you're not waiting. You're not sitting on the fence asking or wondering whether you should ask a question. Yes, you should. I've just told you, ask the question. I want your question. If I don't get questions, no point in me being here, right? I want to make sure that you have the answers, that you feel better. Then when you leave work today or when you go to bed at night tonight, you're feeling better than you did before because you understand your rights, you know what to do, you know what to say, you know what's legal and illegal. All right, right now I'm going to continue answering questions. Let's see, question just came in from Jody. This is Facebook. Let's see. Can my employer ask for a specialist to fill out a form? I gave the form to my attending family doctor, and now my employer wants the same form filled in by my specialist. Can they do that? The answer is no. If your doctor provided your family doctor, clear information about your limitations, then no, they don't get to do anything else. I don't even know, by the way, how the company knows that you saw a specialist. You're not required to tell them that. If you're sick and you cannot work, you're not required to tell your employer what your medical condition is. All you need is a doctor's note saying, for medical reasons, this person cannot work. They don't need to say it's because they're dealing with cancer or because they have a bad back or they're dealing with depression. That's offside. You don't need to say that. So that means that your employer cannot challenge your doctor's note. They can't ask you to get another opinion. They can't demand that a different doctor provide a doctor's note. The doctor's note from a doctor that saw you, that's all you need. Your employer doesn't get to shop around and say, well, hopefully this doctor is going to say something else. It doesn't work that way. So if you can't work, get a doctor's note. If you can work, but you need accommodation, get a doctor's note. What do I mean by accommodation? Maybe you need modified duties or modified hours because of your health. Maybe you need the ability to work from home because for medical reasons, you can't come into the office. Have your doctor say that. Give him a note. Once you have that note, your employer has to make all efforts to accommodate. And they can't say, we don't believe your doctor, we don't agree with your doctor. They can't say any of that. They have to listen to your doctor. That's your trump card, your ace in the hole, if you will, is that doctor's note. So, Jody, hopefully that makes sense. Any follow-up questions, ask right now, and I will make sure that you get more information. Guys, see how easy it is? Another question answered, more information provided. You can do the same thing. You can get your questions answered as well. What an opportunity I'm giving you here to ask me, to tell me what you want to know, to make sure that you're feeling better in a minute or two than you did before. So again, I'm Lior Samfiru, the employment lawyer. Before I continue answering questions, you've heard me talk already a couple of times on this session about severance and about how much someone is owed when it comes to severance. Well, how do you find out? How do you find out yourself without even needing me how much severance you're owed? And by the way, why would you want to know how much severance? Because guess what? It's not a week per year of service. It's not 2 weeks per year of service. For most people, it's much, much, much more. All right. So how do you find out how much severance you're owed? In seconds. You grab your smartphone, your tablet, your desktop, any computer with internet, and you go to pocketemploymentlawyer.ca. See that on the screen right now? Pocketemploymentlawyer.ca. Once you're there, all you have to do is click on the severance calculator. That's it. You are now in the right place to find out how much severance you're owed. You answer a few questions, you hit the button, and it tells you how much severance. 6 months, 12 months, 24 months, anything in between, it's there for you. Completely free. You couldn't pay for it if you tried. It's completely anonymous. You couldn't put in your name if you tried. It's just there as a resource for you. Over 2 million, probably 2.5 million people now across Canada have used it. Use it as well yourself. You'll be glad that you did. Use it if you're curious to know what your severance is, but especially use it if you just lost your job and you're staring at that severance letter and you want to get an assessment of whether what you've been offered is adequate. Pocketemploymentlawyer.ca. And by the way, there's about a 90% chance that the severance you've been offered is not adequate. Okay? Pocketemploymentlawyer.ca. But right now, I'm live, Lior Samfiru, the employment lawyer. I'm going to continue answering questions. I want more, I want more, I want much more. Ask your question as well. Anka has our next question. Our bathroom breaks are being timed and we get written up for going over 10 minutes. If we get written up enough times, we can get fired. Normally, I'm reasonable and I'll comply with the policies, but this is ridiculous micromanaging. I asked for consideration towards the break maximum time for health reasons. I was told to submit an accommodation request and they'll let me know if I'm eligible. Is this legal? It's ridiculous. I don't know why employers do that. That said, the best thing to do is get a doctor's note saying that you need to take longer when you use the facilities. That's it. It's not up to them to say if you qualify. Your doctor doesn't need to say what your medical condition is. That's it, just for medical reasons. That's it. Once they say that, your employer has to give you more time. There's no option. They don't have a say. They don't get to decide. It's not about their opinion. Your doctor decides that. So if they do anything to you, that would be a human rights violation, etc. Even beyond that, if you're let go because you took longer than 10 minutes, that's a wrongful dismissal in the sense that you're going to be owed your full severance. So it's a very dumb thing for the employer to do. Hopefully that makes sense. Let me know if there's any other problems, Anka. Thank you for that. All right, let's continue answering question. Next one from Malcolm. What if your company is bought by a new company? Can the new employer change your wage? So if your job is or your company is being sold and you're offered a job by the buyer, well, if the job you've been offered by the buyer is very different and you choose not to accept it, you're owed your full severance. So it's not a question of can they change your wage, it's a question of what your rights are if they do. So if let's say they change your wage in a significant way, let's say more than 10, 15%, if at that point you say, I'm not going to accept this job, then your previous company, the company that sold the business, has to pay you your full severance because it's a reasonable thing for you not to accept that new job. So that's how that works. Now, if they made a tiny change, maybe they changed it by 5%, that's not going to make you happy. But at that point, if you decide not to accept the job because of the 5% change, you're still potentially owed severance, but not your full entitlement. It's just a small amount. Okay, so hopefully that makes sense. Malcolm, let me know if there's any other questions. Sometimes when it comes to sale of a business, it can get tricky. So best advice is, if you're being offered a job, you're not sure what to do, you're not sure what happens if you accept or don't, call me. Let's talk about your very specific situation. Certainly, if you're not being offered a job, the business is being sold and you're not being offered a job, in other words, you're going to lose your job, you have to call me right away. And of course, to connect with me, to call me, to email me, all that contact information you can find at employmentlawyer.ca. Again, employmentlawyer.ca. All right, great questions today, guys. You see how easy it is. If you've just joined us, if you just logged on here and you want to know what this is all about, I'm Lior Samfiru, the employment lawyer with Samfiru to Martin LLP, and I'm here live, answering your questions, telling you about employment law, telling you about your workplace rights. So you have an opportunity. There's a little box on the screen. You can type in your question, hit enter, and I'll see it, I'll read it, and of course, I'll answer it. And let's do that just now. Next question comes from Demonic Jedi, the winner of the best name of the day. Thank you, Demonic Jedi. Next question from Demonic Jedi. If my current company lost its contract with a business and the new company taking over is offering us jobs to stay, does my previous company owe me severance if I transition to the new company? So the answer generally is yes. If you're going to lose your job with the previous company, you are owed severance. But if you're going to continue working with the new company, that severance is going to be only your minimum entitlements, not your full entitlements, because you don't really have financial losses, right? Because you're going to continue working with the new company. So yes, still severance. But depending on how long you've worked there, it could still be a substantial amount. So if you want to tell me, Demonic Jedi, how long you've worked for the company, and if it's a big or a small company, I can tell you what that severance would be. So it's not going to be your full entitlements, but you're still going to be owed some severance. Hopefully that makes sense. So if you tell me how long you've worked there, and if it's a big company or a small company, I can tell you right now how much severance you would be in the event that you lose your job, but you continue working with the new company. Hopefully that makes sense. I'm still here, so ask the question, not a problem. I want to give you as much information as you need. Guys, I want everyone to have access to legal information. I want everyone to know their workplace rights. I started doing radio shows and TV shows, I don't know, 12 years ago, because I was so frustrated to see that there's misconceptions out there, that people believe things that were not true, that people were confused about their rights and often lost their legal rights because they didn't know what they were. So I wanted to change that, and we've been doing TV shows across the country and radio shows across the countries and these live streams every week so that we can inform you about those rights so that you don't become a victim of lack of knowledge. And a good way to make sure that you're not that type of a victim is ask the question. Don't be bashful. Give me the chance to help you. All right, let's see. Next question comes to us from Sky. I am currently working and have been working at the same place for the last year and a half. I was told yesterday that they will be cutting my hours back immediately to 2 or 3 days. In the past year, my hours have never been cut back. They have given zero notice, and I will not be able to keep up financially. I wonder if I have any rights, possibly constructive dismissal. Absolutely. So if you're going to go from full time for, let's say, 5 days a week to 2 or 3 days a week, that's not something your employer is allowed to do. By reducing you from 5 days to 3 days, that's a constructive dismissal. What does that mean? That means that you have a choice. You can, of course, accept the reduction and continue working 3 times a week. Of course, you have that choice. But you also have the choice to consider this as a termination of employment. In other words, by your employer reducing your hours, reducing your days of work, you can choose to say, that's as if you let me go. And because you let me go, you have to pay me my severance, my full severance. Depending how long you've been there, that could be let's say you've been there for a year and a half. So I don't know exactly the job and how old you are, but that's probably anywhere from 2 to 6 months of severance you're going to be owed. So the options are continue working and accept a reduction, I wouldn't recommend that, by the way. If you accept the reduction, you've given them the right to do it again. So that's option one. Or you can say constructive dismissal. I'm not doing that. I'm going to take my severance and leave. If you prefer that, if you prefer to pursue the constructive dismissal, call me before you do anything. To connect with me, of course, employmentlawyer.ca. Again, employmentlawyer.ca. And by the way, very important, anytime your employer makes a significant change to the terms of employment, this concept of constructive dismissal should apply, or at least you should think about it. Change in hours, change in pay, changing the shift, relocation, anything like that, demotion, constructive dismissal. If that's what happens to you, you got to call me right away, but you have to do it very, very quickly. All right, so thank you for that. Let's continue. More questions are coming in. Love it. Bring them in. You still have time to ask your question. Demonic Jedi had a follow-up. Says, been there for 2 years with a small company. So you'd be owed 2 weeks severance. If you're losing your job, but you're going to continue working with the new company, 2 weeks severance, unfortunately, only. Now, if you didn't have a job with the new company, you could be owed as much as 6 months of severance. But because you're going to have a job and you're not going to be without income, then you'd be owed 2 weeks severance. Now, in terms of benefits, that's up to the new company. Okay, it's completely up to them. All right, thank you for that question. Let's see. Let's get more questions answered. Barb has our next question. Stress caused me to leave work due to a manager. He's no longer a manager, but is still employed at the same store. I was asked to come back to work, but seeing this individual in the store causes significant stress. What can I do? What should I do? So first of all, I want to understand whether or not this is a situation that you told your employer about it and they failed to address it. So if you told your employer and they kind of ignored it, potentially you can consider this situation as a constructive dismissal. You didn't protect me, employer. I told you about it. I gave you an opportunity to fix the issue. You ignored it. So it got so bad that I have to go off on a stress leave. Well, you don't have to continue working in a situation like that. You may be able to say, no, I'm gone. This is a constructive dismissal. By not protecting me, by putting me in this difficult situation, I'm looking at it as a termination. Now you have to pay me severance. On the other hand, if your employer never knew about it, or maybe they dealt with it, they put this manager in a position that they're no longer a manager. At that point, there's not much you can do right now. You can stay off until you're able to go back to work. If you choose not to go back, it may be a resignation. So for it to be a constructive dismissal, you have to show that your employer dropped the ball, that they should have done something but didn't do it. If they did what they were supposed to, or you never gave them the opportunity to do something, then there's not going to be much that you can do. So Barb, hopefully that makes sense. And again, follow-up questions, I'm right here, still got time. Thank you for that. Again, I'm Lior Samfiru, the employment lawyer, answering your questions. Tina has a question. Do you practice in the USA? No. So we practice in Canada, in Ontario, BC, and Alberta. Nothing that you heard me say today applies in the USA. Okay, so none of this applies in the USA. This is only in Canada, specifically Ontario, BC, and Alberta. It does not apply anywhere else. So if you're in the United States, I have no clue what the law is. You'd have to get legal advice in the state where you live. All right, Glory, has our next question. If my workplace has a water leak and I refuse to work until it's safe to do so. Sorry, what if my workplace has a water leak and I refuse to work? Before the day ends, my boss came questioning me about why I stopped working. I felt intimidated. What should I do? Well, I mean, you certainly are allowed to refuse unsafe work. They're allowed to ask you. That's not wrong with that. But if work is unsafe and you refuse to work, then either they fix it or they can call someone from the Ministry of Labor that will decide if the work, in fact, is unsafe. You absolutely have the right to refuse unsafe work. You cannot be punished in any way for it. All right. So I have no way of saying if a water leak makes it unsafe. But if you feel that it's unsafe, you can refuse it. And again, one of a couple things can happen. Either they fix it, or if they don't fix it, they have to call in someone from the Ministry of Labor to look at it and decide if it's safe. If it's safe, they're going to say you have to go back to work. if they say it's not safe, they're going to order your employer to fix that leak. So hopefully that makes sense. Again, if your employer is asking you about it, that's okay. They need to understand exactly what happened. The question is, do they fix it, or do they call the Ministry of Labor, or do they ignore it? You cannot be let go because you refused unsafe work. Okay, so hopefully that makes sense. Any follow-up questions? You still have a few minutes. Ask them. I'm right here. All right. Next question from Harris. What is bad faith termination? Consequences for the employer for that? Well, it's a very narrow type of a situation. There's usually only extreme situations where the employer essentially is taking advantage of the employee. Let's put it this way. Let's say that your employer wants you to sign a new employment agreement, okay? And you sign it. And the next day they say, aha, you know that employment agreement you signed yesterday, it limited your entitlement. So today we're going to let you go and we're going to save a bunch of money. Well, they're taking advantage of you. That's bad faith. So there may be penalties for that, but it's a very narrow subject. In most cases, it's really about severance. So when your employer, if your employer lets you go, 95% of the time, it's really about the severance that they owe you. They may not have been nice. They may not have treated you very nicely, but ultimately that doesn't mean that it's illegal or that there's other recourse. So bad faith really is a situation where the employer is acting in a way that's so offensive, that's so illegal that we are going to punish them. But that's very rare, and it's not something that happens often. Many times I speak with people that are very upset about being let go and how their employer treated them. And I agree with them. The employer did not treat them well at all, terribly. But that doesn't necessarily mean that what the employer did is illegal. It could be morally wrong, ethically wrong, even wrong from a business standpoint, but that doesn't necessarily mean that it's illegal. If you want to talk about your specific situation, Harris, no problem. You can contact me through employmentlawyer.ca. Again, employmentlawyer.ca, and I can tell you whether what your employer did is legal or illegal. Glory had a follow-up. What if he came for retaliation? I'm not sure what you mean by that, what he came for retaliation. He's not allowed to punish you, as I've said. So I'm not sure exactly what you mean that he came for retaliation. If your employer did anything to you, you can contact me, or you can even contact the Ministry of Labor for that, because it's illegal to let you go, to punish you, to threaten you because you refused unsafe work. All right, guys, let's take one more question today, and that question is from Anthony. I have been working as a subcontractor since 2015. They want me to sign a workplace agreement/policy with them. If I don't sign by today, my access to jobs through the platform will be blocked. I want to know if this is something I have to sign. Well, you don't have to sign, but it's quite possible that if you don't, they're going to let you go. Remember, a company can let you go pretty much for any reason as long as they pay you proper severance. So it's possible that they decide not to continue working with you, to let you go, to not give you any work if you don't sign, but they would owe you severance. I know you say you're a subcontractor. The laws probably consider you to be an employee or a dependent contractor. So if you lose your job, yes, you're going to be owed severance. But if you want to know for sure before you do anything, I want you to connect with me, okay, through employmentlawyer.ca. See the phone number there. You see the email address there. It's very easy to connect. Again, employmentlawyer.ca. So when you're asking, do I have to sign? You ultimately have to decide what is better. Is it better to sign and continue working? Or is it better to lose my job and get severance? That's your decision, right? It's a personal decision. Some people may feel it's better to continue working. Other people would rather not sign and get severance. But those are the options. What your employer can't do is say, because you didn't sign, you've resigned, or we're going to let you go and pay you nothing. That they cannot do. They would have to pay you if you lose your job because of it. Guys, that's the time that we had for today. Lots of questions. I love it. Thank you so much for joining me today. Thank you for giving me the opportunity to help you, to answer questions, to make you hopefully feel better and understand your rights. I'm going to turn off this live stream in a second here, but that doesn't mean I'm going anywhere. My team and I are still hard at work. We still want to talk to you. We still want to help you. We want to roll up our sleeves and make sure that your rights are enforced. So you can connect with us now, tomorrow, anytime. just go to employmentlawyer.ca. Again, employmentlawyer.ca, and we'll do that. I'll be back soon. So will my colleagues here. In the meantime, don't wait. Just go to employmentlawyer.ca. Thank you, everyone, for joining me. Have yourself a great rest of the day and a great week. All the best.